Some trials are all about data. The evidence is technical, analytical, numbers on a chart. Some trials are all about stories, the witnesses, what they witnessed, how they acted then, how they act on the stand. And then there's the Karen Read trial, right? Actually, Karen Read trials, right? So today alone, day 6 of testimony in Read's second trial for allegedly killing her boyfriend, the jury got everything I just described and more. The drama came from a prosecution witness named Jennifer McCabe, reprising her testimony about the night John O'Keefe was either hit and killed by Karen Read's SUV, as prosecutors claim, or was beaten to death inside of a house party where McCabe was also a guest, as the defense claims. Now, on the technical side, the defense put a ding in the prosecution's theory that the victim never set foot in the house where Read dropped him off, because for one thing, his iPhone apparently showed he walked at least 36 steps. For another, the defense asserted it was possible O'Keefe unlocked his phone with Face ID and possibly looked at a text. And as it happened, that text was from Jennifer McCabe. On the stand today, just as she did at last year's trial, McCabe described Karen Read as hysterical, screaming, repeating herself over and over when John didn't come home. She talked about the broken taillight on Karen Read's Lexus. She claimed Read said, "Did I hit him? Could I have hit him?" And when she described finding John O'Keefe in the snow, she seemed to tear up. Well, sort of. You be the judge.
When you see Carrie removing the snow from John's face, what do you do?
I was frozen. I was shocked. I couldn't believe that was him just lying there.
Tell us what you're seeing.
What do I see? I see Carrie just wiping the snow off. Karen had straddled him and had lifted her shirt and his shirt and was laying on him, and Carrie was screaming at her to get off of him. And I was literally just stunned. I mean, there he was.
What did John look like when you saw him?
I couldn't see much but his face, because the rest was snow and Karen was moving over him, but he just looked like just him, but just like frozen.
What did you do?
At first, I just stood there for a minute because I couldn't believe it was him. And then Carrie Roberts and I made eye contact. And I knew, I was like, all right, I'm going to call 911. But I think I knew in that moment that John, was dead.
Now, McCabe's testimony ended today just before her infamous Google search, "How long to die in the cold?" How long to die in the cold. There was a misspelling there. That's coming tomorrow, along with what's sure to be a really interesting cross-examination. Let's talk about it. I'm joined right now by Mark Betterow, a criminal defense attorney and former prosecutor who's been following the case since the beginning. He almost joined the defense team, in fact, and currently represents the blogger known as Turtle Boy, who's been covering the case. Mark, thanks so much for coming on. Appreciate it.
Glad to be here.
Okay, so was today a major win for anybody?
I think the defense had a very good day today, not so much with Jennifer McCabe, who's still on direct examination, so they haven't been able to establish anything with her yet, but the witness before her, the cell phone expert for the prosecution, a man named Ian Whiffen, who is supposed to be a very compelling and necessary witness for the prosecution if they're going to win this case. And what you had was the defense put some dents into the prosecution's case by having the witness concede that he could not exclude that John O'Keefe did not go in the house, that his phone did not go into the house. He established that John O'Keefe's phone was used at 12:32 a.m., which is important because the prosecution's theory is that he was struck and killed by a car at 12:31. And it begs the obvious question, how could he be using his phone, his Face ID, touching the side of it if he's already hit?
But just to press you on that, I mean, they also said the phone was inactive from 12:31, 12:32 until 6 a.m. And here's the thing. So Mr. Whiffen, I think, is an important witness. Why? A few things. So he said yesterday that it would be a reasonable assumption that the phone was by the flag post, right? That was by the yard, meaning that the phone never went into the house. Also talked about the temperature of John O'Keefe's phone, that it started decreasing quite rapidly, which would indicate that the phone was outside outside and never inside the house. And if we say we're coupling the phone with John O'Keefe, it helps the prosecution say that John O'Keefe never was in the house. That felt like compelling evidence and something that the prosecution has been relying on, because I don't remember from the first trial, at least the battery evidence.
No, I don't think there was the battery evidence in the first trial, but I'm not sure it actually helps the prosecution as much as people think, because although the temperature clearly came down on the battery, it kind of levels out dramatically several hours later and drops at a much less rate of temperature drop, which may suggest it was actually in some other place, a garage or some other location, not just sitting outside. And the expert did his own test showing that a phone would drop precipitously, the temperature would continue to drop, but there's no explanation for why at 4 o'clock in the morning or whatever it was, it would just, the rate of decline would stop dramatically.
So let's talk about phones for a second. Let's talk about Jennifer McCabe. Really, the big thing is how long to die in the code. Now, the defense would say she looked that up at 2:25,
2:27.
2:27, yep. Right, before John O'Keefe's body was discovered. She'd only be looking that up if she was part of the cover-up. She knew that he was dead. She was a part of it. Now, the prosecution put in evidence from this expert to say, wait a minute, she had opened up a tab earlier on in the day to look for something else, and you can use that tab to look something up at 6:30 in the morning or 6 in the morning. The timestamp would say, this timestamp wouldn't change, but it doesn't necessarily mean you look for that. You search for that at 2-something in the morning, which, by the way, if she really did search for that, she searches for that and then looks up the other miscellaneous things she's looking at. She's a part of a murder and then looks up, what, sports teams or things like that. That's the part that seems, to me at least, that seems compelling evidence that she had a window open but didn't really search for how long to die in the cold until after John O'Keefe's body was found. What's your answer to that?
Well, in the first instance, you have to consider the full context of the 2:27 search. There's going to be evidence, as there was in the first trial, that at 2:22 and 2:23, two other key witnesses, Brian Higgins and Brian Albert, were apparently butt-dialing each other back and forth.
That's weird. Yeah, I agree with you. It's weird.
And that's followed right after this alleged Google search. Now, the prosecution expert clearly says, look, it wasn't at 2:27. He's using his own program, by the way, that he created. The defense is going to have an expert who's going to say it was at 2:27 and it was a deleted search, one of only 4,500 approximate searches on her phone. One was deleted. It just happened to be that one.
But doesn't it seem like if she really was part of this cover-up, this murder, she'd be a little more panicked? Here's the part that I don't understand, okay, right? I don't understand the motive. And I know motive's not an element of a crime, and especially for the defense, they don't have to prove it, but I can understand the prosecution's story here, that either Karen Reed was so upset at John O'Keefe, she deliberately backed up the SUV to run him over, might be shaky, or that she was heavily intoxicated, ran him over recklessly, realized she might have done it, you know, couple that with the idea of, did I hit him questioning it. I don't quite understand what would be the motive for John O'Keefe to go in that house. There's some fight that breaks out. They beat him up, leave him to die, put him outside, and then, my goodness, they frame Karen Reed, and how lucky for them that she goes, you know, and says, you know, allegedly, I hit him, you know, says things that implicate herself. It seems to me, I just don't understand what would be the reason that he would be killed by people in that house.
Well, you may not know the reason, but the framework of the defense starts with science before you even get to what happened in the house. They're going to have expert witnesses, biomechanical engineers, and people with degrees that could go on longer than our arms. And what these individuals are going to say is that there was no accident that's consistent with the damage on the vehicle and damage with the car. And certainly the science would control. And you have to also factor in the burden of proof here. The defense has no burden.
Sure.
Prosecution's got to prove this beyond a reasonable doubt. If these witnesses are credible that there was no accident, then the rest of this is all excess.
I agree, and I've said this to you before we went on air. I cover cases all the time where you hear the defense say this is a tainted investigation, the investigators had tunnel vision. It's a common argument. This is the only one where I say you actually should really listen up. I think they were given a gift with Michael Proctor, okay, lead investigator in this case, right? Completely sloppy, said horrible things about Karen Reed. I get it. But the idea that taillight would be taken and planted at the scene, that there would be this deliberate effort to frame Karen Read. There's so much effort to be put into that. The jury might not need a motive, and they might not need an explanation, but don't they have to say what's reasonable here, what's common sense?
You do, but again, you start with the science. If there is no car accident, but there are 45 or thereabout taillight pieces scattered along the lawn, then how did they get there? If it's not a natural consequence of a car accident, then they got there in some other way. And, you know, your first instinct is to say, come on, how could that be? But then you enter the world of Michael Proctor, and it's not just that he's sloppy, he's corrupt. I mean, he's terminated from employment because of his conduct in this case. He was found to have been biased in this investigation, amongst other things. Beyond looking for nudes, beyond wishing that she would kill herself.
Horrible.
He was found to be biased, so it becomes more plausible. Is there a timeline that it fits? The evidence is going to show in this case that there is a timeline, and then you get to a series of text messages and behavior by Jennifer McCabe, Brian Higgins, Brian Albert, and others who begin texting each other in the days following in a way that is not natural or normal for people who are doing nothing but grieving the loss of their friend.
I agree with you. There's weird stuff, right? Yeah. Why did Brian Albert allegedly not come out of the house? Why was his house not searched? I get it. There's weird stuff. There's a lot for the defense to work with, and she's got great lawyers. Here's the part. Talking about Jen McCabe, right? She said how hysterical Karen Read was, that she was screaming over and over, that Read allegedly said, did I hit him? Could I have hit him? You couple that with Read's statements that she did in the media, which are key pieces of evidence for the prosecution here about speculating if she hit John O'Keefe. You couple that with the testimony of the first responder, Timothy Nuttall, who said, you know, Karen Read said, I hit him. It feels hard to square away why she would have said those things unless she might have had an indication she thought she hit him.
Well,
and let me just add one more thing. The testimony today, too, that while they're searching for John O'Keefe in the snow, Karen Read says, there he is, there he is. How did she know where the body was?
Well, I don't know how she knows where the body is. They're driving there. She comes upon the scene. She sees it. But again, when you talk about statements of did I hit him versus I hit him, you have to consider the credibility of the witnesses. I mean, you take the first witness, the EMT Nuttall. He's a guy who the evidence showed testified a year before that he was as certain as anything that John O'Keefe was wearing a puffy coat like the Michelin Man would wear, right? And it turns out he was wearing a light hoodie, and that he then said his memory got better a year later. He said I heard her say, I hit him twice after I met with the prosecution and another investigator. Now I heard it 3 times. Then you heard Jennifer McCabe say today, well, Karen says everything in 3s. I mean, it feels somewhat contrived.
What are you expecting from Jennifer McCabe's testimony tomorrow? What do you expect the defense to do?
Well, I expect them to expose a series of inconsistent statements that she's made over the course of the investigation. You know, you talk about, she says, I hit him and all these things. Her first statement to the police is nothing of the sort. That comes after the police leave and she meets with the family, has an epiphany, calls the police back and says, I think Karen said, did I hit him? And as the investigation went on and on, that kind of morphed into, I hit him. So I think, you know, that's certainly going to be a primary focus of her cross-examination, as is the text chain between these family members, which don't make sense. I mean, they bring witnesses to their house to be interviewed by Michael Proctor and other cops, and then they're live texting what's happening in these interviews, telling each other she's telling them everything. This is very
Well, wasn't that the idea?
behavior.
She's telling them everything, like telling too much about the relationship between John O'Keefe and Karen Read? Not that had anything to do with the killing, but the idea, like, you're talking about their dirty laundry.
I think that's a hard sell, again, and you have to look at the full context of these messages. I mean, there are messages saying, tell them the guy, their close friend, by the way, but privately, tell them the guy never went in the house. That's a damning message. Why would these people say the story you've got to sell to the media is tell them the guy never went in the house? I mean, you saw Jennifer McCabe today appear to get emotional.
Yeah.
I'm not sure she did. I mean, it looked...
Well, second time she testified, you know, it's about a few years old.
Well, she said when she found him that she got all choked up and nothing came out today. But when you listen to the 911 call, which will come in probably in her direct tomorrow, she's as cool as a cucumber.
Shock?
It's not her friend. John O'Keefe lying dead on the lawn, it's a man.
Yeah.
And then when you see the dash cam video of the police car, she literally turns her back and appears very calm, cool, collected.
I hope everybody can follow this, by the way, because you and I know this case very well. Hopefully we're explaining it perfectly to everybody. I want to know your opinion about the jury view. I'm torn about jury views, whether they're helpful or not. Going to 34 Fairview, Brian Albert's home, where John O'Keefe's body was found, do you think that helped the jury at all? And who did it help?
It helped the prosecution a little, only because of the timing of when it occurred. It occurred way too early in the case. None of the witnesses who were inside of the house or in that vicinity had even testified. If they had, I think that would favor the defense. I mean, you talked about Brian Albert not coming out. The windows that were his bedroom I mean, you could spit from those windows to the flagpole. It's that close if you've ever been to that yard. The jury doesn't know that right now, so they may not be taking that in. All these people inside who apparently didn't hear a car go screeching in reverse, 25 miles an hour, smash into John O'Keefe. They didn't hear it, but we don't know, the jury doesn't know how far away that is, what happened. Nobody saw a body that should have been lying on the lawn. Literally, none of them. They all drove right by it with their bright lights pointing right where the body was. The jury may not yet have that in sight. So
Snowplow driver didn't see it either, apparently.
Snowplow driver didn't see it either.
By the way, I'm pushing you because I know which position you take, so it's not necessarily, I'm kind of divided about what I believe about happened. I think we both can concede. Big mistake for Karen Reed to do media interviews in the midst of an investigation before her retrial. How much of an effect do you think that's having on the jury, and why do you think she did it?
It's hard to tell how much of an effect it's having, other than to say at this point it appears to be their strongest evidence, which is, again, why did you do it?
Because she basically says, she speculates, did she hit him?
It's a mistake to do those kinds of things during, that are going to be used against you at a trial. Now, a lot of those videos were made during the first trial. I'm sure the assumption was there won't be a second trial, but there is a second trial, so there's no question it hurts. I can only assume that they chose to do it to just kind of get the story out to somehow favor them, but there's no question, at least as it's being used in the second trial, it doesn't favor them.
Do you think she's going to take the stand? She's been very vocal to the media outside court. She's been very vocal in these media interviews. She didn't take the stand the first time. I wonder, do you think she'll, what advantage would there be for her to take?
I don't think, first of all, it's unnecessary, and I think it would be too risky. And, I'm obviously not counseling her on what she does, but no, I don't think she'll take the stand.
I have to ask you this question. You're free to not ask it any which way. I know you represent Turtle Boy. Anything you want to say about that? We talked before that you're limited in what you can say. Anything you can say about it?
No, I should keep those thoughts to myself.
That's
for now.
fair enough.
Yeah.
That's fair enough. Okay, so what is another piece of prosecution evidence you're going to be looking out for? Because they talked about the battery evidence that was going to be important. Is there another piece of evidence that you're going to be looking out for the prosecution that the defense really needs to counteract?
Well, I think what's going to be interesting is the prosecution accident reconstruction person, because they know what's coming from the defense side. They have fought like hell to keep it out. Even today, they were there arguing these witnesses shouldn't be allowed to testify. So at the first trial, the person they used to do their accident reconstruction was a Massachusetts State Police trooper who, to be kind, was not a good witness. They've hired a private company. We'll have to see what they have to say. But again, they can't just neutralize the defense witnesses. They have to carry it and convince the jury beyond a reasonable doubt that the defense witnesses are bad. That's going to be a tough burden.
This is a tough case, let me tell you. We went through a lot of it. Mark Betterow, thank you so much for coming on. Appreciate it.
Thanks for having me.
If you've been following the Karen Reed case like I have, every night I do a recap on my Drop Dead Serious podcast, so take a look. You may be forgiven if you feel like you are rewatching an old movie. But like any old movie rewatch, if you pay close enough attention, you actually pick up on things you missed the first time round. Or in Karen Reed's case, stuff that everybody missed the first time round. Take Brian Higgins, for example. He's an ATF agent with deep ties to the Canton police. He was at the house party where John O'Keefe was found frozen in the snow back in 2022. He also exchanged some pretty steamy text messages with John O'Keefe's girlfriend, Karen Reed, before John O'Keefe was killed. If you believe Karen's lawyers, he was part of a cover-up. that police officers at that party killed John O'Keefe and then staged him out on the lawn to make it look like Karen hit him with her SUV. And I get it, murder conspiracies involving police officers, it seems pretty far-fetched, except for the little piece of surveillance video in the trial that just opened a Pandora's box of WTF. The night that John O'Keefe died, Brian Higgins told investigators that he left the party and that he went to the Canton PD to help move some cars because of the big snowstorm that was coming. And he told them that he wasn't on his phone with anybody at 1:30 in the morning, that any calls must have been butt dials. So you can imagine the surprise in the courtroom when a clip of surveillance video was played showing Brian Higgins at the Canton PD on his phone in the dark of night. Mrs. Karen's lawyer, Alan Jackson, grilling one of the lead investigators about that very issue.
If we can go ahead and play this. Stop. Do you recognize the person in this video?
It appears to be Mr. Brian Higgins.
Okay. Who did that appear to be walking away from the camera in this shot?
I'm not certain.
Does it appear to be the same person as Brian Higgins?
It does appear that way, yes.
Okay, if we go ahead and play this through. Pause. Does it appear from this video that the person has anything in his hand?
I really can't tell.
What do you see in that video?
It appears to be an individual wearing a black beanie hat, black dark colored sweatshirt with some design on it, and something illuminating by his face.
Usually when I have something illuminating by my face, it's actually a phone. It would really be great to get a look at the forensic records on Agent Brian Higgins' phone, you know, to see who he was calling that late at night. But nobody can do that because Agent Brian Higgins ditched that phone and trashed the SIM card just after John's death. Curious, I know. And any data that the cops have from his phone came from Agent Brian Higgins himself, you know, the honor system. As for the reason that he was in the hoodie, walking through the police station, he said he was there to move cars. But the video shows him walking around in hallways and doing something entirely different, as well as moving a mysterious bag from one vehicle over to his own car. It's a pretty snowy night. Very, very snowy night. One of the worst blizzards they'd ever had, but you can clearly see he wasn't moving cars. It looked like he had a big bag that he was moving into his car. So again, just very curious stuff. And if all of this looks new to you, me too. This didn't make it into the first trial. So what's in the bag? And what was Agent Higgins doing at the cop shop that night on his phone at 1:30 a.m.? Maybe this is the reason that prosecutors decided not to call him in their case in chief this time round. But that does not mean that Karen's lawyers won't call him. So I'd stay tuned on that one. Any day that a defense attorney can catch a prosecution witness saying two different things that really contradict each other, that is what you call a good day. But it is what you call a great day if it happens in a high-profile murder case and if you're the defendant. Let's take Karen Reed, who's on trial for a second time in Dedham, Massachusetts, for allegedly killing her police officer boyfriend. The prosecutors say she hit John O'Keefe with her SUV and then just left him there to die in the snow. And the witness in question today is this woman, Carrie Roberts. She is a friend of that police officer victim. And she testified at Reed's first trial as well, and also testified for the prosecution. Here's her story. She says that Karen Reed called her at 5 o'clock in the morning, screaming, "John's dead!" And then followed that with, like, he might have been hit by a snowplow. This is bombshell testimony, people, because that call, she says, came in way before John's body was ever found lying in the snow. How could she have known John's dead? How could she have known about a snowplow? How could she have known about snow? Really hard to like get over this, right? Except if you're that guy. If you are Alan Jackson. On cross-examination, Karen's hotshot defense attorney, Alan Jackson, took this witness down a notch. He pointed out inconsistencies between her grand jury testimony and what she said in court. And it all had to do with what this witness claims Karen Reed was saying out loud that terrible morning in the snow. This witness originally told the grand jury that she'd overheard Karen instructing their other friend, Jen McCabe, to Google hypothermia. But as it turns out, on cross, that actually may not have happened.
You painted a very, very detailed picture in front of the grand jury, didn't you?
Yeah.
Except it's not true, is it?
I did not hear her ask that. I was told she was asked that.
The answer to my question, Ms. Roberts, and I'm not a trick question, what you told the grand jurors was not true. You never heard her, my client, ask anyone to Google anything, did you?
I did not.
And yet that's what you testified to under oath, under penalty of perjury, in front of the grand jury, didn't you?
I did.
And the reason you did that, the reason that you said that false statement was because someone told you to say it, correct?
Object.
Is that, I'm going to let her answer that.
Nobody told me to say it.
Still, that's rough, right? That is rough if a defense attorney can point out you said something that you didn't say. That's rough. So there was that today, right? Like wind out of sails, the prosecution. And then a little later in the day, the victim's mom, John O'Keefe's mom, she took the stand for the very first time. Her name is Peggy O'Keefe, and she talked about Karen Reed coming over to visit the morning that she'd learned her son was dead. She said Karen didn't offer condolences. Karen didn't offer a hug. Karen has a different description for this. But the prosecutors added that Karen's sole reason for coming over was to get her car the hell out of there, because they say that car was a murder weapon. So I'm going to stop here. I'm going to bring in somebody who's following all of this as closely as we are. Annie Elise hosts the true crime podcast Seriously with Annie Elise, and she's here with me live. Annie, thanks for doing this. So first and foremost, let's just go to that moment on the stand where Carrie Roberts was sort of really put to the test by Karen Reed's lawyer. I mean, she really did have to admit that she'd said two different things.
Yeah, absolutely. It was interesting because not only was he seemingly catching her in a lie and that she had perjured herself, but all through cross, he was insinuating that her previous statements to law enforcement were colored by Jen McCabe, the same person who he was now insinuating is the one who instructed her to lie to the grand jury and say that she overheard Karen direct her to Google how long hypothermia, when now she's saying she never heard Karen say that. And I think it's very interesting, too, because he brought up, okay, well, when you said that in the grand jury, why did you say the words how long? Because we also know of the infamous Google search, how long to die in the cold. So why would you use those particular words? To which she couldn't answer.
So here's the other thing yesterday when I was watching, and I want to know your perspective in the court, because me, outside of court, I have a very strong feeling about this. Yesterday, it seemed that the prosecution went on at length, laying groundwork with this witness to suggest that she was not friendly with anybody in that house. So if you think she's part of a big old grand conspiracy with all those party goers who, you know, in the defense's view, killed John O'Keefe and then covered it up and framed Karen, the prosecution really wanted to look like this witness is not chummy with those people. Today, once again, that went out the window.
Oh, absolutely. Alan Jackson on cross, she not only was admitting that she and Jen McCabe and some of the others are in constant contact, but it seems like now she and Jen have become best friends since that night in January. And he had alluded to and asked her several times, so would you guys talk before you would make statements to law enforcement? She said yes. They built timelines together. They had conversations, all in preparation for these statements that she gave to law enforcement. And at one point, too, while she was in an interview with law enforcement, Jen McCabe texted her right then and there, too. So again, really inferring that all of her statements and even her testimony isn't that of her own, but more so heavily influenced by Jen McCabe.
And it's for the jury to weigh it, right? To decide how much credibility do I give to this and how much do I not? Okay, so I wasn't sure about this. It's always really hard to watch when a victim's mom gets on the stand and has to answer questions, even from the friendly fire, right? That's the prosecutor asking friendly questions of John O'Keefe's mom. And I watched this as she broke down, and I just thought, oh God, as a mom myself, my heart broke for her. I just didn't understand what this did for the case. Did it do anything, or did it just humanize John O'Keefe?
I think it was meant more as a strategy to humanize him and to also illustrate that this family has just gone through tremendous tragedy and so much loss. And if you pull at the jury's heartstrings that way, of course, that whole courtroom was emotional. Anybody is going to feel emotion during that moment. But what I thought was interesting is after the prosecution had talked with her, for cross, Alan Jackson was like, I just want, I'm sorry for your loss. I don't want to ask you anything, almost to say like, you've gone through enough. You're grieving. I can't imagine this loss, and no further questions.
Yeah, if you're not going to make any points, don't go after a grieving mom. It doesn't do you any good. Okay, last, real quick. They want to play Karen's words against her in court. And this was what we've been waiting for. This is how trial number 2 is going to be so different from trial number 1. One of these clips is under advisement right now. The judge is going to decide tomorrow. And it's a clip from the Hulu documentary. When I watched it, I thought, ooh, that is not going to be good for Karen Reid if it ever gets played in court. And she's basically imitating that mom that morning when Karen Reid came over and they'd all discovered that John was dead. And the words that she uses, and I'm going to imitate it, was sort of snarly. He looks like he got hit by a car. I mean, she's snarling. Karen is snarling. And, this is not going to play well if the jurors see her that callous towards a grieving mom. But do you think this is going to get in? Like, where are we? Or is it 50-50?
So to my understanding, right now it's 50-50. And the reason why the defense was trying to get this out wasn't even necessarily the clip itself. I think that's a piece of it. But apparently they wanted to play this clip directly after Peggy was on the stand. So you have this very emotional mother who's grieving the loss of her son. And then you play this clip where Karen is seemingly mocking her in a way directly following that. And one of the big things everybody's going after is Karen's behavior. She comes across a little unlikable at times, a little bit callous. And so I think that is where the big problem lied with this. I do believe it's going to be under review, and we'll see if the clip gets in, but it could be a little bit tough for Karen to have that play and everybody see that.
Yep. You really get a view of her hardness, and it's not likable, and you want her to be likable if you're her defense attorney. Annalise, thank you so much for this. We'll call on you again. Really appreciate it.
Thanks for having me.
All right, so if you have followed Karen Reid's trial and then her retrial, even a little bit, you will know that a juror from her first trial, the mistrial, is a lawyer who's now on her defense team. Clearly, getting inside that jury's head is a win in itself, which is why I am so excited about my next guest, because he was also a juror in the first Karen Reid trial. Ronald Stanislaw is live with me now. Thank you so much for being with me. I so appreciate this. How did you vote if you don't mind me asking, how did you vote in the first trial?
Voted not guilty on all 3 counts.
You voted not guilty on all 3. What was the breakdown like in the jury room for those for and against? And if you could, tell me also the breakdown of gender.
The breakdown, in general, breakdown of gender, more female than male. And then in terms of the breakdown in terms of, in general, how they were voting, if that's what you're asking, is essentially we were pretty much not guilty on 2 counts, and I guess this is why we're here and we're having this retrial, is because we did not understand the directions very clearly, and that we could individualize or deal with each charge separately. And so we voted for 2 of the charges unanimously not guilty, but
Right.
one charge we were split on, and that was the manslaughter charge. And that's where
I wanted to ask you, though,
deliberated
if I
for
can,
several
Ronald.
days.
I'm sorry to interrupt, but I'm more curious about the breakdown, men and women, and who voted guilty and who voted not guilty when it came to men and women. What was that split?
I don't know the exact number because we were an uneven number in terms of males and females in the group, but I don't know exactly the exact number. I cannot recall how many females voted versus how many males voted guilty versus not guilty.
So it wasn't palpable that all the women, were voting guilty and all the men were voting not guilty. It wasn't obvious like that.
No, it was not obvious. It was not obvious that, if anything, if I were to guess, and again, I'm not 100% sure because we've deliberated on this motion, essentially is that we're about 50-50, if not 60-40.
Okay, so the other thing I want to do is I want to play a clip of Karen Reid's voicemails that she was leaving that night for John O'Keefe while John O'Keefe was presumably dying in the snow. I'm going to play them and I'm going to ask you a question about them afterwards. So let's roll it.
John, I'm here with your kids. Nobody knows what the you want to hurt her. John, I'm going home. I cannot babysit Amy. I need to go home. You're using me right now. You're another girl. Kim's sleeping next to me. You're a loser. Yourself.
Okay, so here's my question, Ronald. When you guys were deliberating the meaning of those voicemails, were you all thinking that's a jilted girlfriend who's angry that her boyfriend is cheating on her, so therefore she could not have killed him? Or were you thinking there's an angry woman who was probably fighting with a boyfriend that she killed that night?
I believe, honestly, that we were split on that, and that some of us believe that it was the rant of an angry girlfriend, jealous girlfriend, and also maybe clearly intoxicated individual. And on the other hand, there was some who probably thought the opposite. So I think that's why we were at a standstill.
Okay, I only have a couple seconds left. I have to make this quick, but have you seen the Hulu documentary about Karen Reid? And if you have, has it changed your opinion at all about voting not guilty?
I think it's changed after that, and now I don't know, right? People have ideas after the fact. That's why they couldn't ask us about our vote after the fact as well. So I would not look at it as a testimony per se, but it's now left to the new jury to decide ultimately.
Right. You were, so I'm out of time, but you were breaking up. Was that a yes or a no that you'd seen the documentary, and a yes or a no that it changed your opinion of anything?
Is a no that I have not seen the documentary and in full, and no, I don't think it's going to change my opinion.
I am so appreciative of your time, Ronald and Stanislaw. Thank you so much, not only for doing your jury duty, but also for being on the show. Thank you for this. A murder case that we couldn't take our eyes off of in 2024 is about to grab us by the neck once again. Opening statements in the retrial of Karen Reid are now just hours away in the same Massachusetts courthouse as the first trial, with the same judge, same charges, and of course the same facts. But this jury may already know those facts going in. I know you do. The police officer boyfriend dead in the snow, prosecution's theory that Reed ran him over, the defense's theory that Reed was set up by cops who had a beef with him that went too far. So who's got the stronger case going in this time round? She doesn't even have to make a case, right? But holy cow, does she ever have one? Earlier today, I spoke with Mark Geragos, renowned criminal defense attorney and longtime friend of the show. Here's our conversation about that. Mark, what's your 30,000-foot view on the Karen Reed case, part 2? I feel like we've been to this rodeo before, and so have many people in that jurisdiction.
I'm very perplexed by this case in a lot of ways. Number one, I don't understand how the prosecution actually got a hung jury the first time around. I mean, you take a look at the evidence in this case, and it just goes to show you that jury selection is everything, because if you gave this case to most jurors would say this is the definition of reasonable doubt. So the second time around, I don't think that it's gotten better for the prosecution. I mean, if you are talking about having an investigating officer or an officer who's close to the investigation getting terminated between trial number 1 and trial number 2, that certainly is a blow to the prosecution.
And also, Karen has been able to hire a juror from round 1 who happens to be a lawyer. And I assume that is pretty powerful ammo.
Oh, I did that once, actually twice, where I've hired a juror from a previous case. And it is unbelievable the insight that you get from the jurors after they have sat on it. I've often said to jurors, and it's not my thought, it's theirs. When I talk to a jury afterwards, it's inevitable. It happens almost every single time that those 12 jurors who are deliberating come up with something that neither of the lawyers thought of was that important. And it was something that kind of supercomputer, artificial intelligence kind of symbiotic relationship of 12 people produces. I mean, it is really an amazing phenomenon, one of the beauties of our Constitution, because they really go deep and they look at it from a lot of different angles.
So the one thing I think of when I think of the overall information that I have learned from trial number 1, from, you know, the docuseries, and even go down the rabbit hole on any piece of social media. But the number one thing I have sort of boiled it down to is that she has a bigger, more robust case that someone else did this than the prosecutors have that she did this. That's fine when you're outside of court, but how do you streamline that and get that to the jury when you're inside of court?
Well, a lot of times the conventional wisdom is that the second trial, and I've had my share of them, so I've seen it. The second trial, the conventional wisdom is better for the prosecution. I don't think that's the case here. I think that they have seen exactly how this has unfolded. I think AJ, Alan Jackson, and in full disclosure, I've known him since he was a young DA. Alan Jackson has the advantage here. I think if you're handicapping this, he now knows where everything is going to be. He now knows exactly what people are going to say or not going to say. That does not help the prosecution because, as you've said, there is a robust case when you tick off the items. Whether it is the coroner, whether it is the injuries to others who were there, whether it's the texting, whether it's the kind of motive of the investigating officer and the horrific things he was saying about her and their predisposition, the fact that there were independent witnesses who did not see what later miraculously turned up. I just think it's as powerful a defense case as I can think of in recent history.
I feel the same way. I can't believe that they chose to re-prosecute just based on the strength of the evidence that Alan Jackson and Karen Reed put together for the first defense. The only thing I think of and this is, I mean, again, this is just off the top of my head, is that the strongest evidence they have against her is that she put her car in reverse and went 24 miles an hour for 60 feet that night at the time when, you know, it all aligns that she dropped him off. But even that, I mean, a lot of people peel out after they've dropped someone off who they're mad at and take off. It doesn't say that you hit them. And then everything else that is strong, broken taillight in that same vicinity. His DNA is on the taillight. His hair is found on the side of the car. Those very strong pieces of evidence are equally blown away by the defense. I've cleaned my taillight off with my hand as a Winnipegger, and that's what John could have done. The hair on John, it could have frozen to the side of that car. That's easy to, you know, there's just a lot of different things that you could explain away, which, as you just said earlier, is reasonable doubt.
By the way, the reversing for a period of time, I think, helps the defense. I think there's an argument there that proves that she didn't hit him, because if she hit him, there would have been some breaking and there would have been some evidence based on what I know about black box technology and the technology that they have, or that they have the ability to extract. I think that actually helps her. I think the fact, you'll remember this, Ashley, because if I remember correctly, you did a show on this, where they flip-flopped the video as well. The prosecution did, which, you know, explanation for that, except you want to just kind of distract and deflect from what the reality is. How do you explain on the one witness, participant, whatever you want to label the person, the scratches on the knuckles? How do you explain that the injuries by your expert, your so-called expert, are inconsistent with getting hit by a car? There is a jury instruction on circumstantial evidence cases, and it's basically the definition of reasonable doubt. If there are two interpretations, one that points towards guilt, one that points towards innocence, even if they're not evenly balanced, you must acquit. And so in a circumstantial evidence case, I just don't get how the prosecution prevails in this case.
Let me ask you one more question. I don't know if they talk about a woman scorned, but it's something that bothers me every time I hear Karen's voicemails to John that night. The tone of voice, the profanity that she uses. I think the state wants to say this is a woman who was so angry, you know, that they were clearly in a fight. That's motive to kill him. I look at it like that's a woman who is so angry at a guy she thinks is currently sleeping with another woman, not sleeping in the snow. And I just wonder how a male defense attorney, Alan Jackson, puts that across to female and male jurors. Is this the voicemail of a woman who just killed her boyfriend? Or is this the voicemail of a woman who thinks he's very much alive and cheating on her?
Well, I don't have as much information as I would like to have from trial one about the male-female composition of who voted for guilt and who voted for acquittal. I would want to know that, because I generally, as a rule, as a defense lawyer, think that women are hardest on women. I mean, that's just been my experience in a whole lot of cases. And I would love to know if that held true, and what the split was, and who held out, and whether or not, if you've got an alternate juror or a juror from the first trial, what kind of insights they give you as to that very issue that you very astutely put your finger on. Because that, you know, a lot of times, and I've been there, you are on the receiving end of they didn't act right style evidence, or this doesn't hew to the common experience. You know that. You traffic in that. And I love your insight on that. That's something that a male may not, or somebody who identifies as a male, may not necessarily pick up on, but I guarantee you that Karen would probably tell AJ that. And I'll bet you that the other juror who's now acting as a lawyer has probably made that same point that you're making right now.
I can't wait for this trial. You got to come back and let's talk through it as we go through the next few weeks.
We may even take a road trip up there and do a field trip into the courtroom. So stay tuned.
Okay, I'm booking you on that day. Thanks, Mark Geragos.
I guess, obviously the first time it ended in, there was a hung jury. So if you had to say, we've been talking to people, second trial's interesting about what changes. If you had to guess now from what you heard, is it where are we going this time? Are we going towards a conviction, acquittal, or maybe another hung jury?
I mean, look, it's hard to say in these cases, but my opinion, I've covered, hundreds of murder cases in my career. I was at the Boston Herald for 14 years. I've been an investigative author for the last dozen years. And it's really hard to get a jury to be unanimous on anything, in any case. In this case, I think it's going to be really hard for them to get a jury to be unanimous in guilt or innocence. So I think my opinion is we're headed towards another hung jury. Obviously, there's a lot of testimony still to go, but I think it's a distinct possibility.
So so Jennifer McCabe, so tell me about this search. So I guess the quick backstory on it is she was at the house in question where O'Keefe was dropped off, and then where he was later found dead outside the house. And there was this search on a phone, I think it was like 2 in the morning or something like that, where it said, well, how long does it take to die in the cold? And people said, what the heck is she searching for that? And he's not found till the next morning. But there were other searches, as I remember it or understand it, at 6 something in the morning, same thing. So the debate seemed to be with the experts about when did she do the search? Was it like, did she open the tab on her phone then? I mean, what was really going on? Do we really know?
We don't, Connell, and it's fascinating that here we are 3 years into this case, and we don't have a definitive answer yet on when that search was actually made. As a lot of these big cases are, as you know from covering all these trials over the years, that it is a battle of the experts, and you have experts on the prosecution side that say, nope, she made the search at 6 something in the morning after the body was found. You have experts on the defense side saying, no, she made it at 2:27 in the morning. The prosecution's expert on this and says what happened was there was a glitch in her Safari on her phone. She actually opened the window that the search was made on at 2:27. But didn't make the actual search until 6 in the morning.
But shouldn't that be easy? Or you're saying it was just a glitch on her phone? Like, in other words, if I open Safari now, it's 5:56 p.m. on my phone, right? And I did a search, who Dave Wedge, who is he? I want to find out about you. And then I don't look at it. Say you're on the show tomorrow. Would it show 5:56? Is that how Safari works? I mean, that should be easy to know. Or was it just on her phone that they're arguing got messed up?
I think they're saying that's the way it works. If you open that window, leave it open. If you open that window search now and leave it open, it will show that search was made at 5:50, whatever time it was made. So that backs up
McCabe's story. That would, would say that she searched for it at 6 something in the morning when Reed came and said, hey, search for this. That's what they're saying, right? Karen Reed told her to search for it, or?
Exactly, that's what they're saying. But it has not been a foregone conclusion. It hasn't been confirmed, and it's again, amazing to me that there's not some expert that can come, not even an expert, an authority that can come and say, no, you're wrong. This is how it works. This is the facts. We don't have that.
The problem
and it's really made a mess of this case.
Speaking of a mess of this case, that's a good point. That's what the problem to me about this case. I was talking earlier about they made the documentary for Max and it was on. The thing for me about it was, on the one hand, you could see, obviously, the argument the prosecution has made and what happened, that she was drunk, she dropped him up, she ran over him, and he died, and he was there. But on the other hand, the amount of mistakes, and this guy Proctor that was investigating, and he's getting, the evidence in a paper bag that was a shopping bag, and then all the texts he sent, and he got fired because he's talking about Karen Reed. The amount of mistakes, if you're on the jury, you could see why. Don't you think why some people would say, well, I'm not sure. I think maybe she did it, but there's a lot of weird things that came up.
Absolutely, and it's more than just mistakes. There's outright corruption involved in this case.
Right.
Whether or not it means someone else killed John O'Keefe, that remains to be determined. But there's no denying that there was multiple police officers involved in unethical.
The guy Proctor, especially, right?
Trooper Proctor, he's already been fired from the Massachusetts State Police because of his actions in this case. There's been other officers that have been sanctioned for their behavior in this case. There's chain of custody issues with all the evidence. There's witnesses giving conflicting statements. And again, you have second trial here And as you know, second trials get messy because what do? They challenge them with what they said in the first trial. So it's much easier to impeach a witness in a second trial.
Karen Reed, the so-called happiest murder defendant in the country, may have fewer reasons to smile tonight after a day of testimony in her ongoing trial that appeared to boost the prosecution's case. Two witnesses who took the stand seemingly bolstered the prosecution's argument that Reed hit and killed her ex-boyfriend with her SUV in January of 2022. A neurosurgeon testified that the head injuries John O'Keefe died from were the result of a backwards fall onto the hard ground. Dr. Isaac Wolf also said the injuries did not appear to come from a weapon, implicitly corroborating the claim that O'Keefe was knocked down by Reed's vehicle. Then a forensic expert with the Massachusetts State Police Crime Lab resumed her testimony from yesterday. Christina Hanley testified that pieces of clear and red plastic that were found on O'Keefe's clothes were consistent with the plastic found from Reed's taillight. And to make matters more interesting, the judge paused testimony briefly this morning to meet individually with each of the jurors about what she called, quote, an issue that had come to her attention. Joining us now is Ronnie Estanislao. He was a juror in the first Karen Reed trial and criminal defense attorney, and a criminal defense attorney has been following this case very closely, Joe Tamburino. Joe, Ronnie, great to have both of you here. Hey, Joe, I want to start with this, the way the day started today, which was the judge sort of shocking everybody by saying, I need to meet with each of the jurors individually, saying this issue had come up. And then she said later on that it was very, very important not to discuss any elements of this case. What do you think is going on here?
Well, thanks for having me on. You know, it was shocking. And normally when a judge, and this doesn't happen too often, in the middle of a trial, in the middle of the day or the morning says, hey, jurors, I have to talk to you privately, that means something's up. Now, many times this would involve, say, a juror talking about the case with other jurors when they weren't supposed to, or perhaps a juror receiving information from outside of the courtroom, or perhaps a juror trying to contact someone outside of the courtroom when they shouldn't be. It probably wasn't something very serious because after this discussion, they simply went back into the jury room and then started hearing the case. But normally that's what it's about. Something got to the judge's attention and she wants to basically tell the jury to make sure they just listen to the evidence and not communicate with anyone.
Well, either it was something serious and she found there was nothing to it. It could have been that as well. But good news that we didn't strike any of the jurors. So let's get to the testimony. Ronnie, you were a juror in the first trial. You've been following the second trial very closely. You do not think that Karen Reed, you've told me on the show before, after being a juror in the first trial, you do not think that Karen Reed is guilty of murder. But today we heard testimony from this brain surgeon. He was a key witness for the prosecution in the first trial, and he detailed how Officer O'Keefe's injuries were consistent with falling backwards and hitting his head hard, not being hit with a weapon. So how did that testimony go over with the jury the first time around?
So the first time around, at least for myself, it seemed to me that he did strike his head falling backwards, but there was nothing conclusive to indicate that the vehicle actually struck Mr. O'Keefe that caused him to go and fall backwards. And that was the piece that was inconsistent. There was no injuries that indicated that. And even with the testimony, both the medical examiner in terms of the mechanism of what caused him to die, not giving any kind of information in her amendment, and the testimony today, to me, it resonates that it still is inconsistent of what was the cause of death.
So you're saying you have a problem. You have a problem with the fact that, okay, he fell and hit his head, and that's what killed him. You still don't know, and you don't think they've proven what caused him to fall?
That's correct. To me, right now, there's not enough information to what caused him to fall.
Okay, so what, and then we have this other witness from the crime lab talking about these pieces of plastic that were found on Officer O'Keefe's body that seemed to match pieces of plastic from Karen Reed's tail light. How did that fly with you?
So in terms of the science behind it, each time they keep saying that it is consistent with the taillight, or any taillight that has similar properties. So it doesn't say that they've matched it to her taillight is what resonates through me. I don't know if that's what's going to resonate to the other jurors as well, but that's what resonated to me, and it's still the same. The other thing that we always considered is that the emergency room floor as well as the ambulance floors are not the best or most sterile environment. And if there's broken taillight because they go to accident scenes or other individuals, patients go to these areas, there could be broken taillight that's there that may be consistent. So again, doesn't resonate to me that it is the cause, and it doesn't connect yet.
And just, and Joe, I'm going to get to you in a second because I got several legal questions, but I'm just curious, Ronnie, was this the way you discussed this in the jury room in the first trial? Like what you're telling me right now, like, well, that's not a sterile environment. That could have come from any place.
We kind of discussed that. We bantered about it during that time, during deliberation.
All right. Joe, you said that today was not a good day for the defense, for Karen Reed. Why?
Well, for everything that you've just mentioned, and this gentleman would be a very good juror for the defense. There's no doubt about it, because what he's saying is he wants absolute proof that this piece of plastic found on Mr. O'Keefe is from this taillight of Karen Reed's SUV. And remember, a trial isn't about absolute proof. Nothing could be absolute proof. A trial is about beyond a reasonable doubt. Does the prosecutor have enough evidence to get beyond a reasonable doubt, not beyond all doubt? And what happened today is that you have these pieces of plastic that is completely consistent with Karen Reed's vehicle. Now, can you say it is exactly the same plastic from that vehicle? No, because there are so many vehicles out there that have similar plastics. But you look at the totality of circumstances. There's no other evidence that there was any other broken taillight car around him. And there's no other evidence that at the hospital there were taillight pieces hanging out in the hallway. And there's no other evidence that at the hospital at the time they were taking care of other people who were hit by some type of SUV. So there's a lot of information that came out today that helped the prosecution.
Well, we can see why this case has captivated so many across the country. Ronnie Stanislow and Joe Tamburino, thank you so much. I really appreciate it.
Well, we are closely tracking the explosive week in court for Karen Reed, the 45-year-old woman accused of hitting her police officer boyfriend and leaving him to die in a snowstorm. There was explosive testimony from Officer John O'Keefe's close friend, mother, and a medic who responded to the scene. Now, Reed's initial trial last year ended with the jury not being able to reach a verdict. Her defense team claiming the whole case is a conspiracy to frame her, pointing to the now fired lead investigator as the orchestrator here. Both sides scoring wins in the courtroom this week, the defense casting doubt on grand jury evidence, and the prosecution reading a series of texts showing Reed and O'Keefe's rocky relationship. We want to bring in NewsNation's law and justice contributor and former FBI special agent Jennifer Koffendorfer on this. Jennifer, thanks for joining us on this case.
Thanks for having me, Natasha.
Jennifer, you've been closely tracking this first week of the retrial. What testimony or evidence is standing out to you the most?
What really is standing out are these video clips that are actually clips that Karen Reed made herself on shows on ABC and on NBC, on Newsmax. I mean, it's amazing everything she's been saying that's incriminated herself.
Tell me more about that. In what way do you feel she's incriminated herself?
Well, for instance, on some of these clips, she has said that she thinks she might have clipped him and that he didn't look mortally wounded. Those are admissions that are really, I think, weighing in heavy on this trial that weren't in the first trial.
Yeah, prosecutors actually played a clip, as you said, of Reed in an interview. The defense strongly objected to this on the grounds it, quote, vilified Reed. Let's actually watch it together, and then I want to get your input here.
And his mother leans over the kitchen island and says to me, I think it looks like he got hit by a car. It looks like he got hit by a car.
So jurors actually left the room while the court discussed this. Why was this clip so hotly debated here? What is the significance of it?
Well, it was debated because the defense said, listen, this is so prejudicial. She's basically making fun of the mother of the victim, and that's prejudicial. But the prosecution said, no, this is consciousness of guilt. She never said anything, but yet she's admitting to the scenario, playing it through the mother's voice. So it was allowed in.
Okay, and then we see Carrie Roberts, who's a close friend of John O'Keefe, making a startling admission in court. Let's take a listen to this, and then I want to get your thoughts.
You painted a very, very detailed picture in front of the grand jury, didn't you?
Yeah.
Except it's not true, is it?
I did not hear her ask that. I was told she was asked that.
The answer to my question, Ms. Roberts, and I'm not a trick question, what you told the grand jurors was not true. You never heard her, my client, ask anyone to Google anything, did you?
I did not.
And yet that's what you testified to under oath, under penalty of perjury, in front of the grand jury, didn't you?
I did.
And the reason you did that, the reason that you said that false statement was because someone told you to say it, correct?
Object.
Is that, I'm going to let her answer.
Wow. So, you know, Roberts never faced cross-examination during Reed's first trial. First of all, help us remember, what is the Google search, this hotly debated Google search that they're referring to, and how significant was this exchange for jurors this week?
Well, the Google search is a debate, but it's really not much of a debate, honestly, whether the Google search, how long to die in snow, took place at 2:27 in the morning or took place after 6:30 in the morning. The confusion by the defense and by many is that the window that was opened at 2:27. In other words, the person, Jen McCabe, was searching Ozone basketball at that time. That window stayed open when she searched at 6:30 in the morning. And that was brought out and clarified, but they're still kind of running with it. But that is the search that they're referring to in that clip.
Okay, I appreciate that. And overall, was week one a win for the defense or the prosecution, in your opinion? And who has a more challenging job ahead of them in this retrial?
The defense has a more challenging job. You know why? They cannot challenge all these video clips of Karen Reed really hanging herself. And that's the biggest problem between that and those text messages where she just sounds crazy.
What's the last thing somebody says after a long-winded story that you're supposed to be fascinated by, but really clearly aren't? Oh, I guess you had to be there, right? Remember that? I guess you had to be there. And you know what? They're right. Being there definitely makes all the difference in the world. So it is a shame it happens so rarely in trials, even murder trials. But you know what? It's now happened twice in Karen Reed's trials for allegedly killing her police officer boyfriend, John O'Keefe. Just like the jury in her first trial, jurors in the Reed trial paid a visit to 34 Fairview Road in Canton, Massachusetts. That is where Reed dropped her boyfriend off after a day of bickering over text and a night of drinking, and it is where John O'Keefe died. Now, how he died, the cause of death, all very interesting questions. Allegedly, prosecutors say, after being hit by Reed's Lexus. But jurors examined the distance from the spot where O'Keefe's body was found to the house where his cop buddies were partying that night. They also saw the alleged murder weapon with a busted taillight. The lawyers were there too, of course, defense, prosecution. But even though Reed herself had gotten permission to go, she declined, saying, "I don't ever want to go back to 34 Fairview," she said. And look, I can't blame her. I'm joined right now, though, by Flint McColgan, police and courts reporter for the Boston Herald, who did make the trip today, paid very close attention. Thanks so much for joining us, Flint. So you went to 34 Fairview 2. Where exactly, though, where was the press located? And I guess what could or couldn't you see?
So it was the same situation as last year in the first trial. We were at a cross street, and it was about, there was like half a very long, suburban block away. So I couldn't quite see the faces of the jurors, but, they were, I could see the lawyers pointing out things that they wanted jurors to pay attention to. And so hopefully that was helpful to the jurors. We'll see how it goes.
What was your takeaway? I mean, I guess one of the big takeaways is, what should we be thinking about, if you can tell us, the distance from where John O'Keefe's body was found to maybe the front door, maybe the distance to the house? Because there's two different theories here, right? He was either hit by Karen Reed's SUV, or he went into the house, was beat up, and then left to die outside. What is the distance from the body to the front door?
So it is a sizable front yard. It's well above average in my experience of suburban front yards. And I don't know exactly how many feet or something, but it is off to the very edge of the property line. So it's quite a distance. If you're looking in that photo there, I mean, those people milling about, they're still really far. So it's quite a distance, but where he was found was very close to the roadway over where that flagpole is and the fire hydrant there. And it's quite a distance from the front door.
So in other words, that seems to help the prosecution?
It could, certainly when you see how close it is to the roadway. But if you are going to take the defense's theory that there was a cover-up and they wanted to make it look that way, obviously you would put it as close to the road as possible. So it's a give or take, really, on that.
It washes itself out. It washes itself out.
Yeah.
Okay, let me ask you about this, though. The jury heard about Karen's blood alcohol content today.
Yes.
And the defense pushed hard that the test used is different from the forensic test that was used in a court of law. Let's play a little bit of that, actually.
You testified earlier today that your lab is accredited by CAP, which is the College of American Pathologists. Do you recall that testimony?
Yes, I do.
But CAP is a clinical laboratory accreditation, not a forensic accreditation, right?
We don't have the forensic accreditation for Good Samaritan.
In fact, Good Samaritan has never been investigated or accredited by any forensic accreditation team to ensure that you perform all of your tests with the integrity necessary to support results in court, right?
We've never been, we've never had the forensic accreditation, but we have very good quality lab results, which I could go into further.
But you've never been accredited by a forensic accreditation team, right?
No.
What do you think the jury took away from that?
So that testimony was quite interesting in that it wasn't very interesting, other than the takeaway of that, you know, even hours after she allegedly killed John O'Keefe, you know, her blood alcohol was above what's the legal limit, you know, and that's even hours of sobering up afterwards. But the weird thing about it is how nearly underplayed that was. We had a very long lecturing about the process and the chemistry about how you do blood extractions, and I could see, you know, the jurors looking back and forth. Their eyes were getting, you know, a little heavy, I believe. So, and it wasn't till the end, and then Adam Lally, who was questioning that witness, was just, what were the results? And then he quit questioning, and it was just like, it just didn't really seem to land. It probably took a few seconds for people to realize, oh, well, he just gave some important information there.
Was the jury paying attention to the last witness of the day, called by the prosecution, this firefighter, this paramedic who rode with Karen Reed to the hospital? What did he have to say?
Yeah, it would be very hard for them not to pay attention to that, because it was testy between the lawyers. I don't think I can remember, at least so far in this trial, maybe the last one is different, but so far in this trial, I haven't seen that many objections. There were 4 different sidebars to discuss the parameters of what he was allowed to talk about. And it all came down to this. The prosecution really wants the jurors to believe that a statement that Karen Reed made in the ambulance as she was being taken for a psych evaluation after John O'Keefe had already been transported. She had said that according to this witness, that she was really worried because her last words, specifically that phrase, to John O'Keefe were ones of anger. And so the prosecution...
Okay. I say, all right, I get it. I get where they're going. I get it. I get it. You know, the idea of tumultuous relationship, incentive to harm him. I get it. I get it. All right, Flint McColgan, thanks so much for taking the time. Appreciate it.
Yep. Okay. Thank you.
You got it.
Jen McCabe will be back on the stand tomorrow, so stay tuned for that. In the meantime, criminal defense attorney and former prosecutor Mark Eiglarsh has a thing or two to say about this trial. Let's start with the tangled web part, because this is the thing I just can't believe, although I guess I need to believe it, because not every town is Boston or New York or LA where nobody knows each other. A lot of towns, literally the whole town knows each other, and you got to pick a jury somewhere.
Right. All right. Once again, I don't share your same emotion for this issue, but there is merit to your argument, the argument that the defense is making, because at a minimum, it gives people like you and others watching this trial the image of impropriety. Hey, judge, why don't you just let one of the other judges handle this? One whose brother wasn't involved with one of the witnesses, etc. That said, if this ends in conviction, I'm fairly certain from what I've heard, this will not then lead to reversal solely because the judge has that connection that you described.
Oh, you're saying that it's not an appellate issue, that this isn't something that's ripe to bring up for an appeal?
Anything could be an appellate issue. The question becomes, and the judge knows that, the question becomes whether an appellate court is going to reverse potentially a murder conviction because of the facts that you brought out that candidly we need some type of chart to follow. But ultimately, when I analyzed it, it doesn't rise to the level where I think the appellate court's going to say, no, she should have recused herself.
Boy, that's bizarre. I always think if you're going to go to prison potentially for decades, it has to be so squeaky clean. But like I said, some towns, the judge knows everyone.
No, it doesn't always have to be squeaky clean. In fact, I found with a number of my cases, the appellate court can say, all right, error was committed, but it wasn't enormous. It wasn't enough to really change the outcome. And so the judge, you know, they could say, well, we find that the judge should have considered recusing herself to avoid the image of impropriety. We don't believe that that resulted in fundamental unfairness where the defendant needs a new trial.
So the other question I have for you, Mark, so many people are invested in the Karen Read case. It's so incredible. Like, it's overseas, it's across the country. And a lot of people became interested in trial number 2 because of, you know, the docuseries on it. But the interesting thing is that it felt when this second trial started that was it. Game over. First 2 witnesses, Karen Read's done, she's guilty. Why is it that people need to hold their horses?
Because what we have going on here with these really talented defense lawyers is what I'm calling a courtroom cha-cha, where the prosecution witnesses take us 1 step forward and the defense goes 1 step back or 2 steps back. The witness says, she said, I hit her, I hit. And then all of a sudden, well, wait a second, you didn't say it here. And yes, your testimony was a little different. So it's 1 step forward, 2 step back. And I think that this is really going to highlight the importance of why that forensic evidence is key. That doesn't lie. That's not subject to interpretation. That will either corroborate the state's case or not.
I love courtroom cha-cha because it's just such a perfect visual experience of what happens. It's like a pendulum, a cha-cha. But how much doubt is reasonable? And I know that's a really tough answer, but I'm just going to ask you for it.
Yeah, I don't know yet that you've got it here. I think this prosecutor is doing a fairly good job of focusing more on the forensic evidence. Plus, I thought bringing the decedent's mother to the stand to add that emotional testimony, it's what prosecutors love. They live for it. They had her on the stand, and boy, she was likable. It was raw emotion. If you've got the forensic evidence to show that she backed her vehicle up at 24.2 miles an hour, which is exactly what they're claiming, and that the other forensic evidence corroborates what these witnesses are saying, then she's going to get what she deserves.
Well, we'll see, because I think you'll agree with me here, and I'm just going to go out on a limb, that Alan Jackson is an incredible lawyer. And if anybody can do it, I think Alan can do it.
I would absolutely concede that.
Keep the tape, everybody. Eiglarsh is agreeing. Hey, Mark, thanks for being on. I appreciate it.
Take care.
I'll see you again soon.